Well, that's the first item this morning, first topic for discussion. Two gentlemen, as you've seen in the welcoming slide, join us this morning. Professor Wahab Egbewole is a senior advocate of Nigeria. He joins us virtually from Ilorin, Kwara State. And we have in our studios in Abuja, Dr. Ernest Ereke, who is Coordinator, Center for Legislative Engagement of Yiaga, Africa. Gentlemen, thank you for joining us this morning. Let me begin with you, Professor Egbewole. First of all, are you as concerned as civil society organizations about the president's assent or not?
But as a Nigerian, one would naturally be concerned because the civil society organization represents the crop of the majority of the Nigerian citizens, in spite of the challenges that they have. I believe that the concern is not more for the non-signing, but for the silence of the presidency until about 24 hours ago, when the presidency came up with the idea that the president will sign within hours. It's 24 hours already, and 48 hours, 72 hours, even if you talk about 1 week, you can still dominate it in hours. So our concern essentially is the ripple effects of the refusal of the president signing the bill at the appropriate time. But we must also appreciate the fact that laws are made for the people and not people for the law. It is our hope that the president will be true to its position that in hours the bill will be signed into law.
Well, let me ask Dr. Ereke in our Abuja studio. There are those who are wondering, I mean, just yesterday we had a conversation about this, and there are those who are wondering, wait a minute, why is there so much talk about this when the election referee, so to speak, has all the powers it needs? Some believe that, look, even with what we have now, it's not really compulsory that the president should sign this bill into law. That it may not make any significant difference because we already have significant laws, especially the Electoral Act, to do the needful, and the Constitution.
Yeah, granted that there is an extant Electoral Act, the Electoral Act 2010, as amended, upon which INEC has relied to conduct various elections in the country, including the recently concluded Anambra governorship elections. But then there are so many reasons why the National Assembly, why citizens, why stakeholders in the Nigerian democratic project, including the president himself. You recall that in 2015, the president did promise and assured Nigerians that he was going to bequeath to this nation a better electoral system, an improved electoral system that restores citizens' confidence and credibility in the electoral process in Nigeria. And therefore, that signifies that there is a noticeable problem and challenges even with the extant Electoral Act. And therefore, it informed all of the resources, all of the energies, all of the time that the National Assembly and Nigerians put into reworking our electoral laws. And on that note, the concerns, being raised by Nigerians with regards to the Electoral Act Repeal and Amendment Bill 2022 will be justified, especially because of certain progressive provisions in that bill. For instance, that bill talks about strengthening the financial independence of the electoral management body. Because if you go to clause 3, sub 3 of the bill, it provides that funds for the conduct of a general election must be released to INEC 1 year before the date appointed for the election. It equally provides in clause 54 sub 2 that citizens with certain
just 1 second.
disabilities, challenges, and
Dr. Reke, if you don't mind, let's stick with this one that you've talked about for a little while, and this which is the number one. I mean, it was your organization that released this document, talking about the early release of election funds to INEC. Let me take that question to Professor Ekpewole. The question that would come to the mind of anyone now is, if INEC already said general elections will hold February 18 next year. And today, we're of course way past, a number of days past the February 18, number of days past 1 year from the general elections. Do you think we're too far gone, or you think it's still within manageable distance?
I believe it's dangerously close to being too far gone. And this, I'm of this view, because at the end of the day, it is not even the activity that matters, but processes leading to such activity. And we have known in the past the challenges INEC had faced with regards to logistics. And even when they plan, the way they planned Anambra, the way they planned the FCT local government elections, at the point of execution, there are challenges. Therefore, if the law in its wisdom of the National Assembly as proposed to the President gives that latitude of time, why do we have to stifle ourselves? Why do we have to make it impossible for ourselves to actively and positively implement what we have voluntarily given to ourselves? That, I believe, is the challenge and the fear of the civil society and, of course, majority of Nigerians. In short, it is not as if we are too far away, but we are dangerously close to being too far away.
Well, this provision that you talked about, Prof, talks about early release of election funds to INEC. So on the one hand, the president is to sign the bill into law. On the other hand, is the timing that between now and the time that the funds will be released to INEC to do the needful. So if let's assume, just as you said, in agreement with the presidency, and the president signs the bill today is the 23rd of February. So the next thing is for INEC to go sit down and say, okay, let's recalibrate. That's assuming that happens. How long then will between now and the time INEC will make that announcement to the time that the funds will be released by maybe the Federal Ministry of Finance or whoever is supposed to release the funds to INEC?
Well, our expectations as Nigerians is that we have voted for a set of people that appreciates us, that we have voted for a set of people that also appreciates the need to have an enduring and sustainable democracy. For me, I believe that the presidency will have factored some of these provisions into its operations, and believe that as soon as the bill is assented to, it becomes operational, and all Nigerians, including the presidency, including the INEC, including the whoever is in charge of the finances that ought to be released, should know that they needed to follow the law. But that is not to say that if we have some elbow room, that the government does not have some elbow room to actually work with. Because, for instance, we had an election 4 years ago. How much did it cost us? As INEC also prepared the cost of the 2023 elections. All these are fine details that needed to be worked out. And my expectation is that since we have this bill, which INEC to which INEC was a critical stakeholder, and they have effectively participated in its emergence, my expectation is that by now INEC must have its own books ready with all the numbers that they need for the purposes of implementation of the provisions of the Act, if and when signed into law, without too much further delay.
Right, let me take this to our guest in Abuja, and still staying on this financial aspect because it's very important, funding elections, which is the bedrock of our democracy. Now, there will be questions as to how the early release will guarantee some sort of financial autonomy. In any case, the money is still coming from the source it was coming from before. But also, speak to this. We're at a time when funds are a bit tricky to get in the country. ASU is currently on strike. They are up in arms with government over funds. The question of subsidy also has to do with funds. Infrastructure funding has to do with funds. And we need to actually spend money on our elections. Does this bill, eventually signed to act, hopefully today, does this also speak to reducing cost of elections? Dr. Reke, can you hear me?
Well, I didn't get the last part of your question, but I heard when you asked if this will help to reduce the cost of elections.
Right.
Whatever the cost of election, while we are concerned and also interested in reducing the cost of elections and indeed the general cost of governance in the country, the most important part the most important thing this provision in the bill tries to speak to or to address is that whatever funds, whether it is 1 billion, whether it is 1 million, that is due for INEC, due to INEC to conduct the general elections, has to get to them as early as 1 year before the date of the general elections. And as Professor Wahab has pointed out, there are so many reasons why this provision has been made in the law. One of which is that we know that INEC has had to grapple with logistics challenges over the years in the conduct of elections. And we saw that play out in the last governorship elections in Anambra State. And then apart from that, there are issues of procurement, there are issues of logistics. And by the time you release funds to INEC as early as 1 year as this electoral law, proposed law stipulates, then you are giving INEC enough time to, to dispense with issues of procurement, and then planning of the elections and enforcement of issues around the elections, will have to be taken care of early enough, instead of just waiting for a few days to the elections before you begin to release funds to elections. And so, yes, while we are indeed concerned that the general cost of governance and elections in the country should, reduce, we're also interested in ensuring that these funds get to INEC as early as possible. Besides also, if you go through some other provisions of this law, it also tries to address these issues of cost of elections, because it addresses all of those issues, some of those issues that warrant the manipulations of elections in the country, and therefore, has the country going back again to conduct elections and spending more funds in the conduct of elections. And that is why civil society organizations and indeed, citizens are asking that this bill should be, signed into law and becomes effective, so that we begin to address, including, the high cost of elections in the country, because it will address some of those issues that, for instance, when you go to court, the court will begin to nullify elections, and therefore all the resources spent, in conducting those elections will have been wasted, and we have to spend more funds, to go back to conducting
So let's dovetail into that point,
by the time we
Doctor,
have this law,
just a moment. Just to add to that, so you can expand on it. So part of the provisions of that law, which is, expected to be a game changer, is now given back into electronic accreditation of voters, legalizing that electronic accreditation of voters, ensure that, it makes provisions for accreditation using the smart card readers or any technological device as may be determined by INEC. On the flip side is the electronic transmission of results. And I just want to know, does this now put an end to that debate over whether or not we have enough network coverage? Is it 60% or 90% and all that? So essentially, this puts an end to that debate. Am I right?
Well, I think it does, and maybe quickly to say that even INEC says it has the capacity to transmit elections electronically from any part of the country. And if INEC is the electoral management body, and it says it has this capacity to be able to transmit from any part of the country, then I think it addresses that concern of whether we have total network coverage across every part of the country. But I want to believe that INEC has reasons for saying that it has that capacity, whether it will be relying on the services within the country, or it has its own way of transmitting these results electronically from any part of the country. For INEC to have made that comment, to have assured that indeed it has that capacity, we want to believe that INEC has the capacity to be able to transmit electronically from any part of the country.
Well, ideally, that would be a given, especially since we have at least one satellite program in the country. But then let me ask Prof this question. For you, because one of the major concerns that we have had over the years concerning our elections is electoral security during the elections. How significantly, in your opinion, does this bill address that concern?
Well, electoral security, like general security of people, lives, and property in Nigeria, electoral security is not different. And it's our expectation that of course, the law has provided the basis and the basics upon which the regulatory agency, the security agency, the political parties, and their agents are supposed to operate to ensure electoral security. But we know who we are as a people. And to that extent, we cannot and we must not take it for granted that in spite of the provisions of the bill, that we will have total unhindered electoral security. However, if we look at the provisions with regards to what transpired on the day of election at the polling station, if you look at the way results are expected to be transmitted, if we look at the way collation is expected to be done, if we look at the powers that has now been given to presiding officer, the returning officers, and the commission itself, we will assume that to a large extent, the security of the electoral process will be guaranteed, in spite of the physical security challenges that we have in Nigeria today.
Well, Dr. Ereke, what's your take on that? Because it's a major concern, election security during the elections, especially for everyone, INEC officials, ad hoc staff, even the security officials themselves, the voters, and all of that. In your opinion, from all of the analysis that your organization has made, how significantly does this new bill, to be signed to law hopefully today by the president, how significantly does are those issues addressed?
Yeah, well, election security has, of course, remained a challenge, as you rightly pointed out. But then the proposed law has some provisions that may deter would-be electoral offenders. For instance, we now have increased sanctions and punishments for electoral offenders of any kind, whether you're a political thug, whether you are snatching ballot boxes, or whether you are compromising the process in whatever way as either an electoral management officer, or you're a candidate, or you are just a criminal wanting to undermine the process. Now, sanctions have been increased. The punishments have been, increased as well, just to ensure that we reduce to the barest minimum, or we deter to a large extent the offenses that people commit during elections. Again, by the time you begin to transmit results electronically, you are also nipping in the bud, the attempt to want to chase INEC officials, or to follow, to chase officials from the polling units, to the collation centers, because results would have been transmitted electronically. And then you're also talking about using technological devices, to begin to accredit voters and as well as transmit elections, as we already mentioned. And so the issues of, for instance, ballot box snatching, issues of stuffing of ballot boxes, which also leads to a breach of security during elections, are equally reduced. And the early preparations also ensures that the security agencies begin early enough to equally prepare for the elections. And so if you take into account some of these provisions contained in the bill, what the bill tries to do is to nip in the bud those factors, that enable people to breach security during elections in the country. And that is why it is important that this bill comes into effect, because significantly it improves the entire process, as Professor Wahab talked about earlier. The most important thing is the process, and the process is leading to the conduct of the election. So there are provisions in the bill that will help us to deter would-be electoral offenders during elections in the country. And that way, we believe that it will significantly improve election security in the country.
Well, when you talk about the process, Doc, processes don't work themselves. Let me ask Professor Egbewole, talking about the process and the people in the process. One of the things that civil society organizations have been concerned about is the electoral umpire, the conversations around the election commissioners, national commissioners of INEC, and the rest of that. But then if you look at clause 8.5 of the new proposed bill, it talks about political neutrality of INEC personnel upon appointment and penalty for contravention. And how significantly, in your opinion, do you see this deterring anyone? Has there been significant deterrence before now? How significantly, in your opinion, does this provision of the law deter anyone who has sentiments for any interest party in an election?
Well, thank you. Political neutrality of people involved in electioneering at the level of conduct of the election has been our laws. And we were all witnesses to the proposal by the government with respect to a particular national officer recently, which the National Assembly graciously blocked, though for other reasons. But I believe that as Nigerians, we must consistently and constantly put our leaders, our rulers on the beat, because every politician thinks about winning the next election. And like Machiavelli, to them, all is fair in war. But to us as citizens, we must constantly engage them to discover the reality that all is not fair in war. A war that is put in place like the electoral process, our laws must be followed. And that is when the war will be fair. So far, good laws. And it's not as if these provisions had not been there in the past. They may not be as potent as we have it now. But what I believe is far more important is the integrity, one, of the regulatory agencies, two, the people, the political class, three, the government. Because if the government is determined to have a free and fair election, there is no reason why somebody that is not politically neutral will have to be put in charge of organizing our elections. Yes, from this provision, the key word, in my view, is still missing. But the sanction of 5 million naira and imprisonment term of 2 years or both may appear to deter.
So, Prof.
Yes?
Yeah, we need to take a quick time out now, but you continue on that thought, because the question is, does that particular provision stop what a political party member or someone who's had affiliations with the party from being nominated? Because it's not quite clear. It doesn't say they must not be, but we'll be back after this break to take on that and so much more. So please stay with us. Well, Mr. Femi Adesina, the president's media aide, said in a matter of hours, and we're counting, it's been 24 hours since he made that statement. The president had, of course, given his promise as well. So let's continue the conversation. We still have with us this morning Dr. Ernest Ereke, who's a coordinator, Center for Legislative Engagement at Yiaga Africa, joining us from our Abuja studio, and Professor Wahab Egbewole, a senior advocate of Nigeria, joining us via Zoom from Ilorin. Just before I come to Dr. Ereke, so Prof, I mean, reading that particular clause, it doesn't say that, I mean, if you have affiliations to a political party, if you're a member or what have you, you cannot be appointed. It just says you need to disclose it. Am I right?
Yes, you are. And that, I believe, is also a window that I believe the National Assembly has created, because they are, like I said, the political class is generally targeted at winning election, free, fair, or otherwise. And that is why I believe this provision ought to have been more stringent. Nobody with any form of political affiliation, disclosure is one. But the fact that you are even involved at all should be a disqualification. And I think this is one of the things Nigerians need to be more involved in. The way Nigerians stood with regards to the nomination of a national commissioner in the recent past. That is, we need to be vigilant to ensure that this provision is given the vent that the law intends to give it. And I think, with respect to the National Assembly, and possibly one would have expected the president, as part of the proposal to the National Assembly, to ask them to have a thinker with this kind of provision. Because by the time you analyze critically those that are in charge today at different levels, either as officials of the commission in terms of public servants, or as the political appointees of the commission, resident electoral commissioner, national commissioner. If you dig deeply, you will discover that at one time or the other, they have been involved. Now, the only body that this provision of Section 85 had put on them is disclosure. And I believe it is not enough to actually deal with this problem that we have dealt with. Except that.
So let me take this to. Sorry, you can land on that before I take this to Dr. Ereke.
Except that with the sanction, maybe people may be deterred.
All right. Well, Dr. Ereke, I wonder if you saw this as well as perhaps a lacuna or something that might need re-amendment, as it were, because in recent times we've had issues like that. And yes, financial independence is good, but also being free from political interference is going to be a major one. And being seen as fair would also be very important for an electoral umpire, I believe. So that on the one hand, and I'd also like to point your attention to clause 84, which has been quite contentious, and that's 84.12, that talks about political appointee at any level shall, no political appointee at any level shall be a voting delegate or be voted for at convention or congress of any political party for the purpose of nomination of candidates for any election. And the thinking has been that, wait a minute, does this infringe on fundamental rights to aspire and all that? So I wonder, is this also something you are concerned as well, perhaps, in this bill?
Okay, thank you very much. We have said that this law is not perfect. The proposed law is not perfect, and there is always, we have a lot of rooms for improvement. While I will agree with Professor Wahab that, for instance, the provision, the clause that talks about political neutrality of those who manage INEC and those who conduct the elections. I also believe that, yes, it can be strengthened further, but that provision is also subject to how you interpret it, because it says that you must disclose. If you do not disclose your political affiliation, then you have committed an electoral offense punishable by either a fine of 5 million or 2 years jail term. Now, that doesn't mean, for me, that doesn't mean that we want you, that the law expects you to disclose your affiliation just for the sake of disclosure. It means that there is an intent within that provision which says that anybody who has this political affiliation shouldn't be involved in the conduct of the election. Because if you look at that provision, it talks about at any level, getting into the commission, to work with commission at any level, whether as an ad hoc staff or whether as a full staff of the commission. Now, if you do not disclose your political affiliation, you have committed an offense. Now, that doesn't mean that the disclosure is just for the sake of disclosure. It is disclosure for us to ensure that we do not have people who are politically affiliated, getting into the commission. Yes, I agree that we can further strengthen that, but this also, for me, is subject to interpretation, even though I agree we can further strengthen it. Then if you talk about clause 84 sub 10, which bars political appointees from being delegates in conventions or congresses or being voted for in conventions and congresses, I also think that these are equally constitutional issues, because the Constitution has provided necessary qualifications and requirements that citizens have to meet if they want to stand for elections at any level in the country. But then I think what the lawmakers tried to do is to prevent this situation where chief executives of states, the emperors we have in our various states, will appoint so many political appointees, and political parties will make them delegates in conventions or congresses. Now, that already rigs the process in favor of these state governors. And so I think that's what the lawmakers tried to do there. But then the most important thing is this. While this law may not be perfect as some persons would want it, now we have room for improvement. The National Assembly is there. We can always go back to the National Assembly and seek for amendments of certain provisions that we feel run at variance with some provisions of the Constitution. But the most important thing for us to do is the law should come into effect. The president, for instance, can send an amendment bill as suggested by Professor Wahab. We have seen him do that with the Petroleum Industry Act. We have seen him do that with the 2022 Appropriation Act. And therefore, we expect that this law should not be delayed. The signing into law of this bill shouldn't be delayed on account of certain provisions that some individuals are not really comfortable with.
Okay.
Of course, the courts are there also to decide on some of these issues, but then also we can exploit the option. We can explore the option, of going back to the National Assembly for further amendments if need be.
Okay. Well, let me take Professor Egbewole up on this one very, very quickly. I know that this bill speaks to early conduct of primaries, at least 180 days before the elections. Everything should be submitted to INEC. But then this particular provision on your screen right now talks about early commencement of campaigns. The question that comes to my mind about this one is how significant a time is this? 5 months, an average of 5 months, from 3 months to 5 months, 150 days before polling day, and that has to end 24 hours prior to the day of the election. And over time, one of the questions that a number of people have been asking is about the leadership recruitment process, the quality of people that are thrown up for the elections. The parties would have done their jobs by this time. Do you think 5 months is enough time for people to interrogate the quality of persons that are to be recruited by them to run their affairs?
Thank you so very much. We have agreed, albeit unofficially, that this bill is a work in progress, is subject to a number of amendments that will further improve our stake as citizens and as participants in this critical endeavor. Having said that, moving from 3 months to 5 months may not be enough, but definitely is a greater improvement. And what we have, to an average politician, they will prefer 30 days, 1 month, so that people will not even be able to identify who and who the candidates are. 150 days may not be enough to actually decipher, assess, and get the best out of these people. But if the process of election is starting just a year before the general election, and given the logistics that are in it, the primaries will have to be conducted, and INEC will have to validate. And don't forget, our political class is generally litigious. They will challenge. I think the 150 days may, as much as it is not enough, we must appreciate that it's a greater improvement on what we have before, and it's something that we need to improve on. If you ask me, I will say the campaign should not be less than 1 year before the election, so that all of us will be able to identify who our councillor is, who our local government chairman is, over a period of time, and be able to question them.
Yeah, even though, Prof, there are those who wonder that even at that point, it's already too late, because the parties already decided who are the people that will represent them, because it's the parties that are going to sponsor these people. So there are those who are wondering, wait a minute, shouldn't we even interrogate at the point of primaries? But then you have to be a member of a political party to do that. Well, that's another conversation altogether, Prof. We have to thank you very much for your time this morning. Professor Wahab Egbewole, Senior Advocate of Nigeria, joined us virtually from Ilorin, Kwara State. Thank you so much for your time this morning.
Thank you so very much for having me.
Yes, sir, as well as Dr. Ernest Sereke, who is Coordinator, Center for Legislative Engagement with Yiaga Africa. He joined us from our Abuja studio. Thank you so much, Doc, for being a part of our conversation this morning.
Thank you. It's my pleasure.
Yeah. Something equally significant coming up right now. Stay with us.